we start. Just make sure everyone's coming through and then we'll get going. Still got a number of people joining. The number's starting to slow now. Hey, Jackie, sun is shining in Cork. Fantastic. So, and Thierry, whereabouts in Belgium are you today?
Brussels, very sunny, and also for the coming days.
Europe is enjoying it in that it's and even the UK will pretend to be part of Europe just for the sake of that comment right now. So yeah, great. Okay, it's slowing down now, so I think we'll get started. So thank you everyone. Thanks for joining our webinar today, where we're looking to talk through everything there is to know about hiring in Belgium. So we're going to focus on some of the compliance and legal considerations that you should be aware of when you're thinking about hiring workers that are based in Belgium. So we've got an interesting audience today. We've got a good mixture of recruitment businesses as well as end hirers. We've got some businesses non-UK, but also we've got Belgium-based businesses joining as well. So hopefully over the next 45 minutes, we can give you some insight in discussing considerations for you when you're thinking about engaging temporary workers in Belgium. And we're going to have to take a specific focus on that key topic that everyone's interested in, no matter which country we're talking about, which is worker classification and the rules that apply and how the Belgium authorities enforce those rules. So from a market perspective, similar to a lot of European countries, the Belgium self-employed market does continue to grow. And it's estimated that there's probably in the region of about 300,000 self-employed workers, which according to the World Bank, that accounts for about 15% of the total workforce. So I think it's clear that this temporary labour force is a critical one for Belgium. And the main sectors that you see those workers operating in tend to be areas like IT, digital, creative, media, consulting work. And I think we've got a couple of consultancies on today, as well as healthcare and the construction trade. So given that there are acute shortages of available talent across most countries and most industries, then it'll be interesting to see how this plays out for the Belgian labour market. And we'll try and give a little bit of insight into that today. So we've planned out a couple of set topics that we'll cover. First one we'll start with is the terms and language that are used within country to describe the various terminology that we use when we're talking about contractor working. And we'll do a comparison to the UK where appropriate. We'll then move on to talk about the main problematic issue of worker classification and how that's dealt with by the Belgian tax authorities. We'll look at the various ways that workers can be engaged by companies that are looking at hiring temporary labour. And then we'll finish off by running through the sorts of providers who can help supply these workers and what the specific legal considerations are to bear in mind from a licensing and a payment process when you're looking at placing workers within Belgium and where relevant in comparison to the UK. So we expect and hope there'll be loads of questions. Please do send them through via the Q&A function. And we're going to leave about 15 to 20 minutes at the end of the session so that we can address as many of those as possible. So today's webinar is brought to you by Giant Group, a leading contingent workforce management company for over 30 years, and Osborne Clarke, an international law firm who advise on a wide range of matters, including employment and tax law considerations involved in the temporary labour market. I'm delighted to welcome the keynote speakers for today, Thierry Vierin. Thierry focuses on employment law and staffing issues, and he's got a vast experience of working with US and UK clients, in particular in that workforce solutions sector. From Giant, we've got Charles Daw, who's director for Giant Global. Charles focuses on helping clients access talent globally and compliantly using Giant Global's international payroll services. Clients include UK recruitment businesses placing internationally, as well as end hirers that are based overseas and who look to hire globally. I'm Dan Haslam, I'm Group Sales Director for Giant, and I'll be the host for today's session. So the format will be simple. I'm I'll pose a number of set questions to Thierry and Charles that allows us to steer us through the topics that we'd like to cover. And we'll try and give an insight into the considerations for businesses when hiring workers based in Belgium, as well as really looking at practical ways that you can mitigate some of those risks. So please do submit the Q&A as we go through, and we'll make sure we address them towards the end. So let's begin then by firstly looking at terminology that we use when discussing temporary labour. There's often variations in how you might describe temporary workers in the UK in comparison to Belgium. So that can lead to confusion, and hopefully we can sort of demystify that a little here. So Thierry, good afternoon.
Good afternoon, Daniel.
So if you could kick us off, please, by just giving us a brief overview of the terminology that you use in Belgium when describing this type of market.
Yeah, so hi everyone. In Belgium, we have a number of terms that we use that are quite similar to the one used in the UK, I think, or in other continental countries in Europe with some nuances. Perhaps the first one is the temporary agency worker. This is typically the person employed by a temporary agency, work agency. That person, and it's an exception to the forbidden staff law that we have in Belgium, that person typically can receive instructions from the end user, as if it was the employer of the worker. Strictly regulated, we will see also that you need a license typically for that kind of activity. Another term we use quite often is the EOR, PEO, so the employer of record. This is typically something we see more and more on the Belgian market. A typical situation is when a company, for example, wants to start business in Belgium but doesn't want to have its own payroll. Typically, they will appeal upon an EOR to have these people then hired by the employer of record. This is something that is not really regulated, but we have in Belgium a system where operational instructions can be given by the end client to these workers. So EOR is something that we see more and more also on the markets. Another term we use quite often is to describe the self-employed workers: contractor, consultant, self-employed worker. This all covers a bit the same. Can be sole trader or a person providing services with a management company. We will come back on that. It's the preferred approach to have a management company used in that kind of situation. But so the difference between a contractor or consultant and an employee is typically that the employee will receive instructions, whereby a self-employed worker or contractor may not receive instructions. That is, of course, of importance in case of reclassification. We will come back on that as well. Manco is used for management company, and again, this is the preferred route when working with self-employed workers. People typically will set up their own management company to provide the services, where they will be the sole, the only shareholder of that company as well. And then consultancy covers typically activities where you use a subcontractor with its own employees who are then put on a project at the end clients. That is what we call consultancy. So pretty similar, I would say, probably than what you use in the UK, Daniel.
Yeah, I'd agree. From a high level, definitely very similar. No unusual concepts that we wouldn't be familiar with from a UK perspective. So thanks, Thierry. Charles, if I could just bring you in here then, if you could summarise the references that typically we use in the UK to describe the same sort of topics.
Yeah, for sure. In the UK, we've got a few different ways that we refer to temporary workers and the way that they're paid. So you've got temps and contractors, contingent workers. They're all essentially the same type of worker, someone who's engaged as a temporary resource to an end client. And in the UK, temporary workers are often engaged by an umbrella company to employ them and pay them compliantly. And so we at Giant Global often get referred to as an international umbrella company. But really, what we are is an international contractor management company. We engage temporary workers in a range of compliant payment solutions. We generally refer to our solution types as employer of record or agent of record. EOR, as Thierry was saying, where there's an employed solution in place, or AOR, where we're engaging with a freelancer or a limited company.
Yeah, great. That makes sense. Looks like we're aligned there in terms of terminology then, for sure. So Thierry mentioned worker classification. That's always the hot topic on these webinars. So let's get stuck into that topic now. And of course, in the UK, we've been discussing this for a number of years, referred to as IR35. But sometimes what's of surprise to people in the UK is that this isn't a new concept, and certainly other countries wrestle with the same challenge around trying to classify whether or not someone's working like an employee or self-employed, and obviously the consequent tax position on that. So Thierry, I'm fascinated to hear from you about the rules around how this works in Belgium. So if you can give us a talk through about how you view that concept of worker classification in Belgium, please.
Yes, Daniel, and indeed, this is a problem that all European countries face, or also in the US, by the way, is the false self-employment. And you said it at the start that we have more and more self-employed workers in Belgium. Why is that? That is because the social security charges are so high for employees. It is even so that a lot of big consultancy businesses now envisage to hire higher management with a management company. People refuse even to be engaged in these big consultancy companies as employees. They prefer to start as sole traders or with the management company. It's really becoming a problem in these consultancy businesses, and they want to open it or to hire their C-levels as self-employed or with management companies.
Well,
so
just
in Belgium,
to say on
yeah.
that, sorry to come in on that. I mean, that is definitely a contrast to the UK, because you're slam dunk inside IR35 if you're within the C-suite there in the UK. You know, if you're an office holder as a CFO or a CEO, that would be really difficult to argue that you're outside. But it sounds as though you really are stretching the boundaries. Businesses in Belgium are trying to stretch the boundaries there, right?
Yes, absolutely. You have to be cautious, because these people will give instructions to employees in the company. You have to avoid that they receive instructions. So yes, you need to put some conditions around it to be very cautious, but it's a trend we see. No, in Belgium, to come back to your initial question, Daniel, we have two statuses, two types of workers in Belgium, not three. It's or you are an employee or you are a self-employed worker. And there are in the law, in Belgian law, 4 criteria used to make the difference. The first one, it's quite obvious, it's the type of agreement you have, the will of the parties, so to say. If you have a nice service agreement in place, that's already a good start. It's not enough, of course, but an agreement with the necessary clauses that will protect you as a user. A second criteria is the freedom to organize their work. It's important that self-employed people can organize their work themselves, do not receive instructions. A third criteria used is working time. Typically, a self-employed worker should not ask for vacation. He should inform, of course, when he's not available, but it's important to make a distinction with employees. He or she should really be able to organize his or her working time, him or herself. And then the fourth one is the possibility to receive instructions. As we said, that's the main one, the possibility of receive instructions. So you should, for example, not oblige a self-employed worker to come to a meeting. You can invite him to a meeting, but not force him to attend a meeting, typically. This is kind of example. So these are the 4 general criteria. In some sectors, like in the construction, or there is a new Belgian law on platform workers. There is also that European directive that will have to be implemented in national laws. But in Belgium, we have already a local law that, based on criteria, creates a rebuttable presumption that people, platform workers, are considered employees if certain criteria are met. For example, the platform worker cannot choose the route to deliver the product, for example. This typically would be a criteria to say that he is a kind of he's an employee. But so the 4 general criteria are these that I mentioned. So the will of the parties, so the agreement, freedom to organize their work, free to organize their working time, and the possibility or not to receive instructions.
Yeah, good. Well, and that makes sense. Definitely a big focus there on supervision, direction, and control of how a worker operates. I hear that echoed in those questions. And then what we call mutuality of obligation in the UK around the will of the parties at the front. Quite interesting, actually, that Belgium already has legislation in place around platforms. That was in place prior to the EU platform directive.
Yeah, absolutely. So. Yeah.
Okay.
Yeah, Belgium was one of the countries pushing for that directive, by the way. We had the presidency of the council at that time. So yes, Belgium has already that act. Yeah.
Yeah. Okay. Good to understand. Okay. So obviously there are some similar themes that are running through between countries, but of course there's going to be differences in terms of the appropriate checks and processes that businesses should be carried out. So it'd be just useful, Thierry, if you could give the audience some practical tips or suggestions about evidence that they say retain or processes they should go through when they're looking at making a decision on worker classification.
Well, yes, there are a lot of tips we can give, but typically the main principle is not to treat the self-employed worker like you would treat your employees. So not have them participate in the same kind of bonus plans, apply to them the same policies. Typically in the agreement, we would foresee also that the self-employed worker can work for other clients so that he has no exclusivity, so to say. And then more in details, you could say, but it's still important not to ask him to hand over reports on a regular basis, not to attend meetings. I mentioned that already. It's really not to treat them as your employees. And treat them really as external partners. Typically also when you will create an email address, you could add external in the email address. It's a detail, but it's important that they have a different email address than your employees typically. Also when they sign in their email signature, typically refer to their management company with a kind of asterisk in small characters. This is typically what is done on a day-to-day basis. I mentioned the Menco, and really that's the preferred route, so to say, when you work with a contractor to ask him or her to set up a management company. The reasons for that are that it's more difficult for a court or a judge to say there is an employment relationship between two companies. That's quite obvious. Even if there is case law that allows the judge to look behind the management company and to decide that there is an employment relationship, but it will be a bit more difficult. Another reason for that is that in the agreement between the management company and the user, you can say that all the tax and social security risks in case of reclassification will be for the Menco, which is not possible in an agreement with a sole trader, with an individual, because that's of public order. So you cannot say that the reclassified employee has to bear the burden of the social security charges typically, but with a management company, you can in the commercial agreement foresee that the risk is for the management company, which means that the consultant would then not ask that reclassification because his Manco will be at risk. Working with contractors remain a gray zone in Belgium, but as you said, Daniel, at the beginning, it's very much accepted in most of the sectors, certainly in the IT, in the consultancy. It would be a drama if the trade unions or the administration would really target these self-employed workers or Mancos, because that would be really at risk for the economy. But you need to remain cautious. But the current case law is rather in favor of the user. It's quite challenging or difficult to ask a reclassification as a self-employed worker.
Yeah, okay, so that's quite interesting. I always think about the different countries that we do these webinars on a sort of scale of level of risk.
Yeah.
And it sounds like Belgium's not, certainly not as risky as in Germany or potentially in the UK. I mean, how much activity is there in the courts on cases like this? Is it quite benign, or is there actively cases that do come up on these misclassification points?
Well, we have some cases here at our law firm that we deal with, but no, not a lot. Again, I mean, it's certainly when you are highly paid. When you have a kind of C-level, courts will rather difficulty accept that you would ask the reclassification typically. Yeah. And the administration also has other tasks to do than come into the companies and to look at false self-employment. So the risk is mainly when somebody is terminated, typically, that person could be tempted to ask for indemnities and arrears of salary, vacation pay, etc. But again, I mean, you need to have a strong file, so to say, to get that reclassification. Yeah.
Yeah, no, good. Well, I think it's great then that the Belgian authorities recognise the value that flexible labour force has, and aren't really trying to step in the way of it. It's not necessarily the case in all countries, as we said. So thanks for that, Thierry. Charles, if I can bring you back in here, obviously from a giant global perspective, you have to wrestle with this misclassification point on a regular basis. So how is that typically managed by global payroll businesses?
Yeah, for sure. I mean, it is a very interesting question, because it's something that I've been working on for a number of years, and certainly if you go back 5 or 10 years, then self-employed was absolutely the main way of working for contractors around the whole of Europe. But we've seen more and more governments bring in legislation to move temporary workers into an employed option, like the Platform Workers Directive. And of course, the reasoning behind this is that governments collect more tax and social security from an employed solution compared to self-employed. I think, as you mentioned earlier, over here in the UK, we had the IR35 legislation. And so what we've done is we used the IR35 test that we have over here. We've actually combined that with other legislations around Europe, like the WAB legislation in the Netherlands, AG legislation in Germany. We also brought in some information from worker classification in the US. And our legal team kind of worked on that along with the help of an AI engine to kind of produce an international version of an IR35 test. Now, the upshot is that the test that we've developed, it's not a legally binding document, but what it's been designed to do is to give a really good guide to someone so they can see how they should engage a freelancer, or actually should it be an employed model. And so some of the things that Thierry was talking about earlier around that kind of, the supervision, direction and control, all of that sort of thing is within the questionnaires. And it really just puts an extra layer of due diligence into assessing how to engage your temporary workers. And I guess ultimately to the authorities, it shows that you're following a process in your decision making, as opposed to just looking for the cheapest and the quickest option. And we certainly feel that that's a much better argument to be putting to a tax authority if there was a reclassification case, that you've actually followed a process. And it's just to add on as well, it's interesting what Thierry was saying about when cases are bought, because this is certainly something that I've seen in the past, that one individual contractor being investigated is often unlikely. What I've seen is that either you have a large corporate entity that is perhaps having a big investigation where the authorities feel that something is not working correctly, and they'll try and mop up everybody within an investigation into a large corporate. Or you have this case where Thierry was talking about, where someone comes to the end of their contract and they think, actually, do you know what, I didn't get any holiday pay and I think I'm owed something. And so then an individual brings a case. But it's often those types of scenarios that I've seen in the past, as opposed to just one individual person who happens to have an investigation into them.
Yeah, and I suppose it's an important point you've both made there, that actually on misclassification, we always think, I do anyway in the UK, it's contractors wanting to be, payrolled not as an employee, but in actual fact, you will have people absolutely wanting to go the other way. You see that with the cases like Uber, where people want to argue for additional employment rights, and obviously the money that comes with that. So it's important to see both sides to that coin. Just a quick reminder to the audience, please do submit your questions into the Q&A function. We'll have time at the end of the session to go through those with Thierry and Charles. So if you were sat there with any particular questions you wanted to ask, then please do put them in the chat and into the Q&A rather, and we'll come back to those at the end of the session. So Charles, we'll stick with you onto the next topic now, where we're looking at moving on to think about ways in which a worker can be engaged and the sort of different types of suppliers that can provide these workers to hiring organisations. So can you tell us a little bit more then about the services that are provided by employer of record and agent of record companies like Giant Global, and how that can help a client to engage these types of workers?
Yeah, for sure. So look, an EOR service essentially is an employment option. The worker will have an employment contract. It could be open-ended or it might be fixed term, but each month essentially there's a payroll that will be run. The worker would receive a net pay along with a pay slip. All taxes would be deducted at source. All employer costs would be paid directly to the local authorities. and the worker is then really just able to focus on the work that they're doing for the end client, and all of the administration associated with them being paid is kind of taken care of for them. And then conversely, with the AOR, or Agent of Record Service, that's where someone is operating as self-employed or perhaps through their own limited company. And with that solution, the worker would receive a gross payment, and it would be part of their responsibilities to pay their taxes and social security directly to the authorities. So essentially, there would be some more administration to do for the individual, so a little bit more work on their side. But ultimately, when you do qualify to operate as self-employed or as a limited company, you then don't have those employment costs. So the reality is that your net pay will probably be a little bit higher because there's less money going to the government.
Yes, and that I suppose feeds back into the commercial point that Thierry was making at the beginning there, which is when, if someone is to be engaged as an employee, then of course you've got those, social security taxes that need to be paid, and that often either drives up the cost to the hirer, or it's going to potentially reduce down the actual rate of pay to the worker. And they're the sort of commercial tensions that need to be worked through on these things. And Charles, are there any other forms of engagement that you'd mention?
Sure. Sorry, Dan, I was just going to add to that as well. When you are also talking about countries like Belgium, when we're over here in the UK, used to our now 15% employers' national insurance costs. In Belgium, I think, Thierry, you can correct me if I'm wrong, but I think we're over 30% in Belgium. So it's a very significant sum of money that is going to the government from that employer costs.
Well, let's hope Rachel Reeves isn't attending today, so I don't think she needs any more encouragement to increase our current taxes, but that's another topic
Absolutely.
for another day.
For sure. And sorry, to your question, Dan, look, generally we try to use EOR or AOR as a catch-all, but there are different terminologies within those structures, like company to company or sole trader, or as Thierry was mentioning, Manco, for example, in Belgium. And then you can also have things where people are perhaps directly sourced, or they're subcontracted, or again the consultancy agreements, again that Thierry was mentioning earlier, that can exist in Belgium.
Yeah, and typically those consultancy engagements tend to be based on deliverables, don't they, and milestones, as opposed to a typical hourly or daily rate. There's obviously other nuances to it as well, but at a high level, that's one of the differentiators there. So thanks, Charles. Useful summary. It'd be good to hear from you, Thierry, about your views on these different worker engagement types and considerations, please.
Yes, and we touched upon at the start of the webinar. So one of the most common used is, as we said, the freelancer contractor model. We have a new government since a number of months, and it took only 300 days to form that government. You know that in Belgium we have a kind of record. Last time it was 550 days. So at least we have a government. It's a right-wing government, but we were afraid that they would touch upon self-employed workers and mancos. But fortunately, the measures announced by the new government will only be minor. They will be, for example, to benefit for the reduced corporate tax rate for mancos at 20%. You will need to pay the director of that company 50K instead of 45K per year gross at least. So there's a kind of minor change. Also, the benefits in kind paid to the director may not be more than 20% of the total remuneration. So they will tweak the existing legislation a little bit, but Manco will not be discouraged by the new government. Again, as I said, prefer to use a Manco as a service provider rather than a sole trader. I would say that the management company is certainly interesting for the individual, as from the moment you earn 120, 150,000 per year, so to say, then it becomes really tax efficient. Consultancy. I was referring on the term consultancy when you appeal upon subcontractors and their employees. And there we can touch upon the forbidden staff loan, which is a kind of general principle in Belgium, but we have a kind of exception to that. You have the temporary agency workers, that's the first exception. A second exception is that limited instructions, operational instructions, can be given to the employees of another company if these limited instructions are clearly noted written down in the commercial agreement between the two companies. So that's a kind of important exception. You need to know to allow that people from company A receive instructions from company B. This is a kind of exception to the forbidden staff loan in Belgium. And this is also what justifies the use of EOR in Belgium. As I said, it's not really regulated as such, but again, with that kind of instruction right clause, if I may call it like this, the user will be able to give some instructions, operational instructions to the employees hired by the EOR. And then we also mentioned temporary agency model, which is strictly regulated and also applies more to blue collar workers typically. Yeah.
Okay. And how just on that last point there, in terms of the blue collar piece, is that defined by pay rates, or is it just a feel of the type of work that people are conducting tends to lend itself to temporary as opposed to Manco and the other forms that you mentioned, Thierry?
Yeah, it's typically indeed the type of work, because these people in general need to receive instructions from the end user. So the end user really wants to behave as the employer. There is also a cost aspect, because the temporary work agency will take a percentage, a margin. Typically, if the salaries are rather low, you will feel it less as a user than when you are talking about people with high remuneration. Though that's why typically it's more applied to blue collar workers, even if it could also apply to white collar workers. But yeah.
Okay, no, that makes sense. And then finally, just on that, obviously we see in other European countries there are licensing requirements for recruitment agencies to operate in Belgium. I just wonder if there's any similar concepts in Belgium as well for businesses that if we've got a UK agency on here today that wants to set up in Belgium, are there any considerations there?
Yeah, good point, Daniel. And even if we are a small country, we still have 3 regions, which is the Flanders in the north, where we speak Dutch, Brussels, bilingual, and then the South Wallonia. Because that matter is regulated on sector level. So in case of permanent staffing, really the headhunting activity, so to say, when you find candidates for employers, there you would need a registration in Brussels and Wallonia, but not in the Flanders typically. So that's the kind of first kind of license you would need in 2 regions out of 3. The temporary agency work, that is strictly regulated. There you would need a license in all 3 regions, so to say. So these are the 2 type of license we have in Belgium. The permanent staffing and then temporary work agency. Yeah. But so when you work with contractors, when you place contractors at end clients, typically you won't need a license. Unlike other European countries, I think, but perhaps Germany or other. So this is a business where you don't need a license. The license is really for the permanent staffing, and what I call the headhunting activity, or then the temporary agency workers. Yeah.
Okay, great. Well, there you go. I think all signs are, for any contract recruiters on the call, that Belgium's open for business, and you should be focused on it as a territory for sure.
Absolutely.
So great stuff. Again, we're going to be moving to the final section of the session now. So if you do have any questions that you want me to pose to Thierry and Charles, then put them in the Q&A, and we'll make sure we cover those before the end. Charles, given that Giant Global operate in a wide range of different countries, then it must be very challenging for you to manage. So it'd be interesting to know a little bit more about how you and the other global payroll providers address these different complexities in different regions.
Yeah, definitely challenging for sure. So it's a combination. The reality is that we have our own internal team who are experienced in international payment solutions. At Giant, we also have our proprietary software that really allows us to deliver our services globally, because it is a platform that we've developed in-house that is multi-jurisdictional and multi-currency. But then also we have our network of specialists like Osborne Clarke, who are based locally in each country in which we operate. And they're really able to feed back information to our teams when things are changing, so that we can kind of formulate how we need to adapt our offerings and make sure that we continue to provide compliant solutions to our clients. And I would say that this is one of the key aspects of being able to deliver and operate in as many countries as we do. Without that kind of trusted partner network, it just wouldn't be possible, because you'd need to have kind of a lawyer on the ground in each country almost. So we happily lean on companies like Osborne Clarke to help us instead.
Yeah, absolutely fantastic. Thanks, Charles. So yeah, we're moving on to the final topic now, which is just having a look, horizon scan into the future. What potential other legislation changes are there that are upcoming, that you might want to flag to the audience, Thierry?
Yes, I think there was the first one that we flagged already, and in Belgium we have already a law on platform workers. But I mean, for other European countries, you need to look out at local law, national laws, transposing the European directive on platform workers. That's certainly one to look at. Another directive that is coming and that needs to be transposed in national laws on continental Europe is the Pay Transparency Directive. You probably heard of, that needs to be transposed by 26. With this directive, Europe wants to tackle the pay gap between men and women, which is still, I think, 13% in Europe in general. And so it will oblige employers to really be more transparent about pay levels. And so all companies are already starting to work on this. You don't have to wait for 26. That is to set the pay levels in your the job descriptions first, then the pay levels per job level, etc. Because even candidates will have a right to have information on the pay levels, etc. Which will bring more transparency on the market, I think, and that could have an impact on the margins. You will more easily know what your subcontractors pay to their employees, so there will be more visibility on that on the market. So that will change a bit the way business is done. And also, I think there are some opportunities for HR consultancy businesses to help clients, companies to structure their pay levels, to help them with that. So I think there is certainly business there to take for staffing businesses in general. Yeah.
Yeah. Okay. Well, that's an important flag. We have similar concepts with requirements on businesses in the UK to report on gender pay gaps. So sounds like that's a theme that's carried over there. So very welcome. Great. Well, thank you both for sharing your insight. I think that's been super useful to understand some of the variations and the specifics around Belgium, and hopefully the audience appreciated those topics. As anticipated, we have got a number of questions coming through, so let's move through to the Q&A part of today's session. Again, if you've still got questions, please submit them and we'll work through them as many as we can. So not in any particular order, but let's pick out a couple to get going. So first question here from Anna. Are the licenses needed if we are wanting to have an entity in Belgium, or would these licenses also be applicable for business being generated from the UK? So
yeah,
what was your view on that, Thierry?
Yeah, good question. No, even a foreign company with clients in Belgium will need that license. So you have a lot of UK companies who are licensed in Belgium because they have clients business in Belgium. So that's not the reason not to have that license. So to say you can do the permanent staffing remotely, but if you work for Belgian clients, you will need that registration or license indeed. Yeah.
Yeah, and just to recap then on that, you were talking us through the requirements in the different territories or regions within Belgium. What's the factors that dictate, which of those territories you need to register in?
It's typically where the client you work for is located. I mean, if you work for a big consultancy business in the Brussels region, you will then need to apply the Brussels legislation on that part. Yeah.
Yeah, client location. That makes sense. Thank you. Okay, next question from Charlotte. Hi, Charlotte. If as a UK agency we wanted to place workers under an employer of record like Giant and not payroll employ the workers directly, would we still require a license, or should we check the employer of record has the necessary license? Charles, do you want to come in on that, and Thierry to add any further comment?
Yeah, for sure. So I guess ultimately you always want to check what licenses your suppliers hold, and I think ultimately it will come down to that question that Thierry was raising earlier about how much control and supervision is being applied by the end hirer. If it is just this limited written supervision within the contract, then the EOR can operate without the license. If it is kind of literally every day full supervision, direction and control, then that license is going to need to be in place, I believe.
Yes, and if I may add on that, so the user, the end user, don't need a license. The EOR, like Charles says, if it's temporary agency work, would need a license, but not if it's just a payroll activity where you hire people, and you can people who can then receive instruction from the end user based on that instruction right clause I was mentioning in the commercial agreement. So no license needed in that scenario, I would say.
Okay, good. And just a further question from me on that, Thierry. If the worker was classified as being suitable to work for a Manco, and let's say Charles as Giant Global was engaging that worker and running the payroll, would there still need to be a license in place to make a payment to the Manco, or is that license specific to employer of record type engagements?
Yeah, the license is linked to an active, but the first line is on permanent staffing. We're talking about employees, candidates to be employed. And the license for temporary agency work is also for employed people. So for a Manco, typically you would not need a license to place contractors or Mancos to work with Mancos. That typically doesn't need, which is the benefit of the activity in Belgium, contrary to some other European countries where it would be more tricky, I assume. Yeah.
Yeah, no, that's good then. So just for clarification, the license is required where it's employer of record type engagements or those other formats, as opposed to Mancos or consultancies. But be careful, you need to get your you need to get your classification checks correct there and not make a mistake. So that all ties in. Thanks. Just a quick note from Suzanne. Charles, can you provide details of payment packages to use the Giant classification tool? So there's one there for you to follow up separately with Suzanne. Question from Ruza. Ruza asked, what are the main advantages and disadvantages of hiring temporary workers via staffing agencies in Belgium, particularly in terms of compliance risk and workforce flexibility? So what are the main advantages and disadvantages of hiring temporary workers via staffing agencies in Belgium, particularly around compliance risk and workforce flexibility? Thierry, do you want to come in on that first?
Yes, so the benefit of using temporary agency workers, if that is the question, for the end user is that you are allowed to give instructions as if they were your employees. The benefit is that when you have a peak of work, you can appeal upon these works. You don't need to have them on your payroll. That's quite obvious. The disadvantage is that there is a cost linked to that. This agency will take I don't know, a 30% margin on the cost, on the salary costs. So it will be a kind of expensive way of using contingent workforces. Yes, it's strictly regulated, but that's then more an issue, I would say, for the temporary work agency, even if as a user you need to provide information on the job description. So it's more regulated, more administrative work than using the employees of a subcontractor, typically based on the instruction right clause. So it's a bit more administrative work. Yeah.
Yeah, that makes sense. I suppose from on that point on margin, obviously a chunk of that is going to be around the employment tax piece, but equally the business is charging to deliver that compliance service and those checks and those licenses, etc. So you're outsourcing some of that compliance risk, and of course then the agency would charge for that. I don't know, Charles, if you've got any additional comments you want to make around that question, or if Thierry's covered it nicely.
Yeah, I would just reiterate that I think the advantage is that they are set up and ready to go with the license in place. So it's probably around speed of delivery is the advantage that they can provide. But as Thierry said, but then there's the additional cost involved.
Yeah. Okay. Next question from Chris. What are the requirements for BVCA and or VCA VOL for workers to be employed. So it's B-VCA and or VCA-VOL for workers to be employed. Does that resonate with you at all, Thierry, that question?
Yes, that's a kind of an official registration. It comes from the Netherlands, if not mistaken. When you want to work in some industries, like in the chemical industry, that's a kind of registration you have to show to your end client. Look, we are compliant. So VCA, yeah, that's what we were saying. Yeah.
Yeah, it's B-capital V, capital C, capital A, and or VCA-VOL.
Yes, if not mistaken, that's the kind of registration in some sectors that you would that some end clients will request for your company to provide services. Yeah,
and that applies in Belgium as well as the Netherlands, you think? And it's more an industry driven.
Yeah, it's an industry driven registration.
Okay.
Again, it's yeah, absolutely. It's a kind of absolutely industry driven, and so yeah, some end clients will ask it in Belgium as well. Indeed, yeah.
Okay. Here's an interesting one from Mark. So he said that the message is NATO. Several years ago, the tax office came on site, SHAPE, and held all the British staff for 6 hours. These workers were not allowed to leave the room. This resulted in a mass exodus, approximately 1,500 contractors. Mark himself went back for a second contract post-Brexit and didn't even get past the commune part. So I gave up. Do the UK agencies now fully understand the process? So there's an interesting scenario there, obviously relating to several years ago. I don't know if Thierry, you've got any observations on that.
Yeah, well, I have some experience. I know that the social inspection will typically come down on construction site. I know there was an issue also with the Google site some years ago, where they would tackle contractors coming from Eastern Europe, typically without necessarily be compliant. These contractors sometimes receiving instructions on site. So you need to be cautious when you provide a lot of contractors, electricians, for example, on a construction site, because they're typically the social inspection will come down and check. It's true that now with Brexit, that contractors coming from the UK will in general need a professional card, which is a kind of work permit for self-employed people, which is quite tricky, can be quite long, for 4 or 5 months to get it. Okay. So yes, working with UK contractors or from contractors from outside the European Union has become quite tricky indeed. Yeah, I don't know if that answered the question, but
no, I think it does. I think Mark's making an observation there, and post Brexit, it has created some challenges. Who would have thought that? Anyway, moving on. So, yes, Charles.
Dan, I was just going to say I had a little bit of experience with some contractors in NATO a few years back at a previous company I was at, and the scenario was that I think the worker was trying to claim that if they were engaged by NATO, that they didn't have to pay tax in Belgium, and that they were still taxed in their home country. And we did some research into this at the time, and I believe if you are engaged directly by NATO, then you don't pay tax in Belgium, you pay it in your home country. But once you put a what we call like a contract chain in place, so that NATO were engaging a UK recruitment agency, who were engaging ourselves as a payroll company, who were then engaging the worker, that then broke that rule for NATO, and so Belgium tax was required. So again, I think just if specifically for NATO, you probably have to look into what are the contract chains and engagement types to see what rules you need to follow.
Yeah, brilliant and good insight there. And Mark's even dropped a note back saying correct, Charles. So he obviously understands exactly. You're welcome, Mark. Okay, so coming to the last couple of questions. One from Sithideth. Stay with you on this, Charles. For workers under employer of record, are they entitled to automatic pay increases with inflation?
Oh my goodness. Interesting. It's not something that I've had a huge amount of experience with, in fairness. Essentially, when we provide an employer of record solution, it is genuine employment, and so we would absolutely have to follow rules within the country in which we operate. So I would hazard a guess to say yes, but that would probably be something that I would go to Thierry to get the definite confirmation on.
It's a good answer, Charles. No, I can add on to that. So indeed, your EOR business will probably fall in Joint Committee 200, which is typically the Joint Committee for Service Companies. And on the 1st of Jan each year, you have an indexation of salaries, which is automatic and of public order. So in Belgium, unlike other European countries, you have that automatic indexation in most sectors. And so you will need to take into account these indexations. It was very high some years ago. It was once 11% one year, and then last year it was more around 3.5%. But yeah, over the 4 last years, we had increase of nearly 20% when you add the automatic indexations over the last 4 years. So salaries have gone up in Belgium more than in other countries, probably. Yeah.
Yeah, well, great question there. I think that was a great question to ask because it's brought that topic to light. You obviously need to be mindful of what those inflations are going to be if you're placing contractors on a long-term basis. That potentially needs to be priced into the commercial consideration based on that.
Yeah, I was also talking about employees, of course, employees and contractors. So there are the rules of depending on the agreement. But I was talking, about the employees on role.
Yeah, no, makes sense. A question from Nassim. What about Limosa forms?
Yes, the Limosa forms is the declaration of employment in Belgium that you have in other European countries as well. So as an employee who is not submitted to Social Security in Belgium, you need to inform the administration so that they are able to check. And the same rule applies for self-employed workers, except in certain sectors. So there's a declaration of employment that you have in nearly all European countries to allow the administration to have these kind of checks.
Okay. And then final question again from Nassim. I think it was just a clarification point. So he was just asking, so you don't need a license if you are placing contractors in Brussels as a British agency?
No, I confirm. So no need of a license in Belgium to place contractors. Absolutely, because it doesn't fall under the license of permanent staffing. It's not permanent staffing because we are not talking about employees.
Yeah, but if that were, so as long as you're happy, Nassim, that you've done your classification checks and that person's genuinely not an employee, then you're good to go.
Yeah, again, be careful for the professional card we were talking about. If it's a UK contractor, not the same as placing a French contractor in Belgium, for example.
Yeah. Great. Guys, fantastic. Thank you very much for your time there and taking the time to answer those questions at the end. That was really, really super useful. Thank you to the audience for attending today. We can leave you now to maybe enjoy some sunshine for the remainder of lunch. And we'll hopefully see you on the next session. We've got a number of other webinars planned. One point I would say is that we're on our follow-up, we'll send a follow-up email out, and on a separate note, Giant are currently fundraising for Great Ormond Street Hospital. So we don't charge for these webinars, but if you'd like to make a donation to that charity, then please do so, and we'll include the link on the follow-up. So thank you, Thierry. Thank you, Charles, and thank you everyone else. Good afternoon.
Cheers, everyone. Bye-bye.
Bye.